without any basis. That was the number one. Yep. The number two major error in the applications was omitting Carter Page's prior relationship. Now, we now have evidence that Carter Page functioned as a source for a United States intelligence agency. That's a pretty darn important fact. If you're telling the FISA court, hey, the fact that this guy Carter Page, who I don't know this guy Carter Page, but the fact that he's talking to Russians, really suspicious. Well, the fact that he's serving as a source for U.S. intelligence agents is pretty darn relevant to why he's talking to Russians, because we have lots of sources that are talking to bad guys. And when you don't tell the court that, you're deceiving the court. But it's worse than just deceiving the court. Because, as the OIG report details, an assistant general counsel in the FBI altered an email, fabricated evidence, and reading from the OIG report, specifically the words, "and not a source," had been inserted into the email. That email then was sent on to the officials responsible for making the decision to go forward. And as the report said, let me read on page 256 of the OIG report, the final paragraph. Consistent with the Inspector General Act of 1978 and following OIG's discovery that the OGC attorney had altered the email that he sent to the supervising agent, who thereafter relied on it to swear out the final FISA application. So the men and women at home need to know what's happening. A lawyer at the FBI creates fraudulent evidence, alters an email, that is in turn used as the basis for a sworn statement to the court that the court relies on. Am I stating that accurately?
That's correct. That is what occurred.
Now, you have worked in law enforcement a long time. Is the pattern of a Department of Justice employee altering evidence and submitting fraudulent evidence that ultimately gets submitted to a court, is that commonplace? Is that typical?
I have not seen an alteration of an email end up impacting a court document like this.
In any ordinary circumstance, if a private citizen did this, fabricated evidence, and by the way, what he inserted was not just slightly wrong, it was 180 degrees opposite what the evidence said. So the intelligence agency said this guy is a source, and he inserted this guy is not a source. If a private citizen did that in any law enforcement investigation, if they fabricated evidence and reversed what it said, in your experience, would that private citizen be prosecuted for fabricating evidence, be prosecuted for obstruction of justice, be prosecuted for perjury?
They certainly would be considered for that if there was an intentional effort to deceive the court. On this one, I'm going to defer because, as we noted here in the sentence you indicated, we referred that over to the Attorney General and the FBI Director for handling.
Third major omission that the Department of Justice and the FBI did not tell the court is that this entire operation was funded by the DNC, was funded by the Hillary